Welcome back to the deep dive. Have you ever looked at a contract and wondered, well, who really gets to enforce it?
It seems simple on the surface, doesn't it?
Right. You and I make a deal. It's our deal. But what if our contract says one of us has to do something specifically for someone else, someone who wasn't even at the table?
Does that third person have any rights? That's the million-dollar question.
Exactly. That's the puzzle we're diving deep into today. The, well, sometimes tricky world of privity of contract and third-party rights.
Yeah, it really gets to the core of what a contract is. Is it purely a private bubble for the two parties involved? Or can it ripple outwards and affect others legally?
Historically, the law was pretty strict about that bubble, wasn't it?
Oh, very strict. And as we'll see, that strictness caused some real problems, genuine injustices, and major headaches for businesses, too.
And for this deep dive, we've got some fantastic source material to work with, made available by the University of London, specifically for educational purposes. We're really grateful for that.
Absolutely. It's great material.
Our mission today is to take all this detailed information, break it down, find the most important bits, and give you a shortcut to really understanding this area.
Whether you're studying, working, or just, curious about how contracts work in the real world.
And we're thrilled that this deep dive is brought to you by Sinorbit Academy, Sri Lanka. They're doing great work supporting learning journeys.
Hear, hear.
And look, for all of you listening, maybe with exams on the horizon, and we know this topic comes up, we really want to say good luck for all of you for the exam. Seriously, best of luck.
We hope this discussion helps things click into place for you.
So the sources lay out a clear path for us. We're talking about the old school doctrine of prativity.
Right, the traditional strict rule.
Then the big statutory change, that 1999 Act.
The Contracts, Rights of Third Parties Act, 1999, yeah. A landmark piece of legislation.
And also these sort of clever ways the courts tried to get around the strict rule over the years, the common law devices.
Exactly. Techniques developed both before the act and which, importantly, still exist alongside it.
So you've got this inherent tension, haven't you? The legal idea that contracts are private versus the everyday reality that people want to make contracts that benefit others.
Yeah.
How did the law handle that?
Well, for a long, long time, the law came down hard on the side of privacy. The historical cases we'll look at really show that, but the pressure just kept building. The results were often just too unfair, too impractical.
Leading to change eventually.
Big change, yes.
Okay, let's unpack this. We need to start with that traditional rule, the doctrine of privity itself. See the problems it created through some key cases. Then we could explore the modern fix, that 1999 Act, and those older common law workarounds that are still relevant.
Sounds like a solid plan. So the doctrine of privity of contract. At its absolute core, it's about who can be legally involved with the contract after it's made.
Who gets to play?
Pretty much.
Yeah.
The fundamental principle sounds simple, but wow, the implications are huge. In general terms, only person who is a party to a contract can enforce it. Let's repeat that because it's central. Only parties to the contract have rights and obligations under it.
So if you didn't sign on the dotted line, you're out.
Traditionally, yes. And this doctrine usually gets broken down into two distinct parts, or aspects. Understanding both is, well, it's crucial.
Okay, what's the first aspect?
The first aspect says that only parties to a contract are bound by it. So A and B make a contract. They cannot, through that contract, foresee a third party to do something or to not do something.
Right, like you and I can't agree in our contract that our listener has to, I don't know, send us coffee.
Exactly. The source uses figure 11.1. A contracts with B, and they try to write in a term saying C must pay B 100 pounds. That's unenforceable against C. Why? Because C never agreed to the AB contract.
That part seems pretty fair, actually. You shouldn't be saddled with obligations from a deal you weren't involved in.
Generally, yes. This aspect preventing burdens being imposed on third parties isn't usually seen as controversial. It feels intuitively right.
Okay, so that's the burden side. What about the second aspect? This is the one that caused all the trouble, I gather.
It really is. The second aspect is the flip side. Only the parties to a contract can derive rights and benefits from their contract. This means A and B cannot, in their contract, legally give C an enforceable benefit, even if that's precisely what they intended to do.
Hold on. So even if our contract explicitly says host speaker agrees to pay extra speaker 500 pounds and also promises to pay listener 1,000 pounds for, say, being a loyal listener.
Under the strict traditional rule?
The listener couldn't actually sue me for that 1,000 pounds.
Correct. Under the old common law rule. Figure 11.2 illustrates this. A contracts with B. B promises A they will pay C £100. That promise is unenforceable by C. C can't sue B for the money because C wasn't a party to the AB contract.
Wow. Okay.
This is the aspect that caused so much criticism because it flies in the face of the party's own intentions. It often led to results that it just felt wrong and could be commercially absurd.
It does seem fundamentally unfair. If A and B agree C should get something, why should the law block C from getting it?
Exactly the criticism. And the source material drives this home by looking at some really important House of Lords decisions that showed just how rigidly this rule was applied and the problems it caused.
Let's walk through them. These case names are important to remember. First up, Tweddle v. Atkinson.
Yes, Tweddle v. Atkinson,
Yeah.
all the way back in 1861. A classic example of the problem with the benefit aspect. You have two fathers, the father of the groom and the father of the bride.
Okay.
They make a written agreement with each other. Each promises to pay a sum of money to the groom, Mr. Twiddle, after the wedding. The groom's father promises £100. The bride's father, Mr. Guy, promises £200.
Like a contractual wedding present from the fathers-in-law to the groom.
Precisely. But then the bride's father, Mr. Guy, died before paying his promise, £200.
How?
So the groom, Mr. Tweddle, the person who was supposed to get the £200, sued Mr. Guy's estate for the money.
Makes sense. Did he get it?
No. The court held that Mr. Twiddle, the groom, could not sue. Why? Because he was not a party to the contract. The contract was between the two fathers. Mr. Twiddle was a third-party beneficiary.
Even though the contract explicitly named him and promised him money.
Even so, the court also mentioned he hadn't provided consideration for the promise, which is another contract law element, but the main barrier was privity. He was a stranger to the contract.
So the father's clear written intention was just overridden. That feels really harsh.
What starkly showed the rule's potential for injustice. Okay, let's jump forward to a major commercial case, Dunlop Pneumatic Tire v. Selfridge & Co. from 1915.
Dunlop Tires, Selfridge department store.
That's the one. Dunlop sold tires to a wholesaler, Dew & Co. Their contract included a term saying Dew couldn't resell the tires below a certain list price. Dunlop wanted to maintain prices.
Okay, price maintenance. Common practice.
Dew then sold tires on to Selfridge. In that contract, Dew included a term trying to bind Selfridge to the same minimum price, and Selfridge even agreed to pay Dunlop £5 for every tire they sold below that price.
So Selfridge knew about the restriction and agreed to it with Dew.
Yes, but then Selfridge went ahead and sold the tires below the minimum price anyway. Dunlop, the original manufacturer, sued Selfridge directly to enforce the price restriction and claim the £5 per tire.
Could Dunlop sue Selfridge directly?
No, the House of Lords said Dunlop could not sue Selfridge. Why? Because Selfridge was not a party to the original contract between Dunlop and Dew, and Dunlop was not a party to the contract between Dew and Selfridge.
Even though Selfridge promised Dew they'd pay Dunlop.
Didn't matter. No privity between Dunlop and Selfridge. This is where Lord Haldane gave that famous statement. Only a person who is a party to a contract can sue on it. He also stressed the need for consideration moving from the person trying to enforce the promise. Dunlop hadn't given consideration to Selfridge for their promise to Dew.
So Dunlop's whole price control strategy was sunk because the party breaking the rule wasn't in a direct contract with them. The doctrine is really biting here.
Absolutely. Rigidly applied. Okay, let's look at a different kind of benefit, not money, but protection from liability. An exemption clause. This is Scrutton's Ltd v. Midland Silicones Ltd, 1962.
Okay, exemption clauses. How do privity affect those?
Right, so you have a goods owner, let's call them A, who contracts with a carrier B to ship some chemicals. The AB contract contains a clause limiting the carrier's liability for damage to the goods to $500 per package, standard practice.
Okay.
The carrier B then hires stevedores, C dock workers, to unload the ship. The stevedores are subcontractors. They have a contract with B, but not with A, the owner.
Owner A contracts carrier B. Carrier B contracts stevedore C. Got it.
While unloading, the stevedore C negligently drop a drum, causing nearly $1,800 worth of damage. The owner A decides to sue the stevedore C directly in tort for their negligence.
Okay, suing the people who actually dropped it.
Exactly. Now, the stevedore C want to rely on that limitation clause in the contract between the owner A and the carrier B. They argue, look, that clause was meant to protect not just the carrier, but anyone handling the goods, like us.
They're trying to use a clause from a contract they weren't party to as a shield, a negative benefit.
Precisely. Could they do it? The House of Lords, by a majority, said no. The stevedores were strangers to the AB contract. Therefore, they could not take advantage of its provisions, even if those provisions seemed intended to protect them. A stranger cannot benefit from a contract.
This is the one where Lord Denning dissented strongly, wasn't it? Arguing for a more commercial approach.
Yes, famously so. His dissent really highlighted the practical problems this caused in shipping and commerce and sort of foreshadowed later developments. But the majority view in Scrutton's held firm to privity.
Okay, one more crucial case. The very personal story of Beswick v. Beswick, 1968.
Yes, Beswick v. Beswick really brings the human impact home. An elderly coal merchant, Peter Beswick, sold his small business to his nephew, John Beswick.
Uncle sells to nephew.
As part of the deal, the nephew promised to pay his uncle £6.50 a week for the rest of the uncle's life. Crucially, he also promised that after the uncle died, he would pay the uncle's widow, Ruth Beswick, £5 a week for the rest of her life.
A clear intention to provide for his wife after his death. Very common.
Absolutely. So the uncle died, the nephew made one payment of £5 to the widow, and then he just stopped paying.
Oh dear. So the widow sued him.
She did. She sued the nephew to force him to make the weekly payments he'd promised her late husband he would make to her.
And applying the strict privity rule.
The House of Lords held that the widow, Mrs. Beswick, in her personal capacity, could not sue the nephew to enforce the promise. Why? Because she was not a party to the contract. The contract was between her husband and the nephew. She was just the intended beneficiary.
Another intention defeated by privity. That's harsh.
It absolutely was. But, and this is the crucial twist in Beswick, the widow was also the administratrix of her late husband's estate. She was his legal personal representative.
So she wore two hats.
Yeah.
Herself and the representative of the person who was a party to the contract.
Exactly. And the House of Lords held that in her capacity as administratrix of the estate, she could sue the nephew. The estate could enforce the promise made to the deceased uncle. And because damages wouldn't be an adequate remedy for the estate itself wasn't losing £5 a week, the court ordered specific performance. They ordered the nephew to specifically perform his promise, meaning he had to make the £5 weekly payments to the widow.
So she got the money in the end, but not directly based on her own right under the contract. She had to enforce it through the estate.
Precisely. It showed the promise was enforceable by the promisee, or their estate, but the third-party beneficiary herself still had no direct contractual right. It perfectly highlighted the barrier privity created for the person meant to benefit.
Okay, so let's recap those two aspects of privity. Aspect 1. No imposing burdens on third parties, generally seen as fair.
Broadly unobjectionable, yes.
Aspect 2. No conferring enforceable benefits on third parties. This is the one shown to cause problems in Twiddle, Dunlop, Scrutton's, and Beswick. It frustrated intentions, led to injustice, and caused commercial inconvenience.
You've nailed it. The criticism really focused on that second aspect.
Given how problematic it was, why did it take so long for the law to change fundamentally?
That's a good question. The source suggests one reason might be those common law devices we mentioned earlier. The courts themselves, perhaps seeing the unfairness, developed these clever, sometimes slightly artificial ways to get around the strict rule in certain situations.
Like finding loopholes.
Kind of. Legal workarounds. Because these existed, offering some potential solutions in some cases, it perhaps lessened the immediate, overwhelming pressure for Parliament to step in with a big statute for a while.
Okay, so the courts were patching things up. But eventually, that wasn't enough.
No. The patches weren't consistent, they didn't cover all situations, and the underlying problem remained. The calls for reform from academics, judges, and the Law Commission grew louder and louder.
Which brings us to the big one. The Contracts Rights of Third Parties Act, 1999.
Exactly, the 1999 Act. This was the direct legislative response to the problems caused by the benefit aspect of privity. Its aim was very clear: to reform, but crucially, not abolish, the doctrine of privity.
Reform, not abolish. What's the distinction there?
It means the basic rule of privity still exists, but the Act creates a major exception to the benefit aspect. The core goal was to give effect to the contracting party's intention when they intend to confer an enforceable benefit on a third party.
So if A and B make a contract and genuinely want C to be able to enforce a benefit under it, this Act gives C the tool to do that directly.
That's the essence of it. The Act provides a statutory route for a third party to enforce a contract term in their own right, provided certain conditions are met. But remember, as the source stresses, the Act does not allow A and B to impose a burden on C. The first aspect of privity is left largely untouched.
Okay, focused on the benefit side, how does the Act actually work? What are the key sections we need to know?
The absolute heart of the Act is Section 1. Section 1, subsection 1, or Section 1.1. lays out the two main ways a third party can gain the right to enforce a contract term.
Okay, two gateways. What's the first one?
The first gateway is Section 1.1. This says the third party can enforce the term if the contract expressly provides that they may.
So the contract itself explicitly says third party X can enforce this clause. Dead simple.
As clear as it gets. If a parties write that in, the third party has the right. That's the express route.
What's the second gateway? This sounds like the more complex one.
It is. Section 1B says the third party can enforce a term if the term purports to confer a benefit on them.
Purports to confer a benefit. What does that mean exactly?
It means the term, on its face, looks like it's intended to give a benefit to the third party. It aims to benefit them, or appears to do so. Think of the promise to pay the widow in Beeswick. That term clearly purported to confer a benefit on her.
Okay, so if the clause looks like it's for the third party's benefit,
then presumptively they can enforce it under S.1b. But, and this is a big but, this is immediately qualified by Section 1.2.
The qualification. What is Section 1.2?
Section 1.2 acts as a crucial check on S.1b. It says that the right under S.11b does not arise if, on a proper construction of the contract, it appears that the parties did not intend the term to be enforceable by the third party.
So even if the term looks like it benefits the third party, if the contract as a whole suggests the original parties didn't actually want that third party to be able to sue on it, then S.1b is switched off.
Exactly. It comes down to interpreting the contract to find the party's intention regarding enforceability. The presumption raised by S.1b can be rebutted by evidence of contrary intention in the contract itself under S.12.
So interpretation of the whole contract is absolutely key here. It's not just about happening to benefit, it's about whether the parties intended that benefit to be legally enforceable by the third party.
You've got it. That's the crucial balance the Act strikes. And Section 1.3 adds another requirement. The third party must be identified in the contract.
How identified?
By name or as a member of a class, like employees or subsequent tenants, or as answering a particular description, like whoever unloads the ship. Importantly, they don't actually have to exist when the contract is made. Think future children or future purchasers.
Okay, name, class, or description. And they can be identified even if not born yet. Got it. Let's look at how the courts have applied this. Nishin Shipping Co., Ltd v. Cleves & Co., Ltd. from 2003.
Yes, Nishin Shipping. A good early case on the Act. It involved ship charters contracts between ship owners and charterers. A third party, a firm of brokers called Cleves, had arranged the charters. The charter contracts included clauses stating that commission was payable to Cleves.
So the contract between owner and charterer said commission goes to the broker, Cleves. Cleves is the third party.
Right. When the commission wasn't paid, Cleves sued the ship owners, relying on the 1999 Act.
Could they enforce that commission clause?
Yes. The Court of Appeal held they could enforce the clause under Section 1B. The commission clause clearly purported to confer a benefit on Cleves. The court then looked at Section 1.2. Was there anything in the contracts to suggest the parties didn't intend Cleves to be able to enforce it? They found nothing. So the presumption held, and Cleves could sue.
And did it matter that benefiting Cleves wasn't the only purpose of the contract?
Good point. The court said no. The Act doesn't require the benefit to the third party to be the sole or even main purpose of the term. As long as it purports to confer a benefit and S.12 doesn't negate it, the right arises.
Okay, that clarifies S.1b and the S.12 rebuttal test. How about Prudential Assurance Co., Ltd v. Ayers in 2007?
Prudential v. Ayers basically reinforced the Nishin approach. It confirmed that if a term, properly interpreted, purports to confer a benefit, the third party can enforce it, even if the term benefits others as well. The focus is on the intention regarding the third party's benefit.
So the purports to confer test seems fairly wide initially, checked by the intention test in S.12. But how do courts distinguish between a term that genuinely purports to confer a benefit and one where the benefit is just a side effect?
That's the crucial distinction drawn out in Dolphin Maritime and Aviation Services Ltd v. Sveriges Angfartigs Assurance Forwarding, 2009.
Dolphin Maritime, what was the key point there?
The court clarified that for Section 1.1b to apply, conferring the benefit on the third party must be one of the purposes of the bargain struck between the contracting parties. It's not enough if the benefit is just an incidental consequence of one party performing their obligations.
Purpose versus incidental effect. That sounds critical.
It is, and two more recent cases from 2019 really illustrate this contrast. Chudley v. Clydesdale Bank and Bates v. Post Office, No. 3.
Okay, let's take Chudley v. Clydesdale Bank first.
In Chudley, there was a contract, a letter of instruction between Clydesdale Bank and an investment company called ARC. This letter specified how money invested by clients in an ARC scheme should be held by the bank, essentially in a separate client account.
So the investors are the third parties here.
Exactly. ARC went bust, the money wasn't properly segregated, and the investors lost out. They sued the bank directly, relying on the 1999 Act.
Could the investors sue the bank under the Act?
Yes, the Court of Appeals said they could. Why? Because the specific terms in the letter about segregating client money clearly purported to confer a benefit on the investors, the benefit of protecting their money. And crucially, protecting those investors was found to be a purpose of that contractual arrangement between ARC and the bank. The investors were identified as a class under S.13. So S.11b applied, and S.12 didn't negate it.
That makes sense. Protecting the investors was a core reason for that clause. Now, contrast that with Bates v. Post Office, No. 3. This was part of the big Post Office Horizon scandal litigation.
Correct. The specific issue here was whether assistants who worked for sub-postmasters could use the 1999 Act to sue the post office based on the contract between the post office and the sub-postmasters, their employers.
So the assistants are the third parties. Could they sue the post office?
The court said no. The argument was that the contract required sub-postmasters to provide adequate training, which would benefit the assistants. But the court decided that any benefit to the assistants from training was merely an incidental effect of the sub-postmasters fulfilling their duties to the post office. It wasn't a purpose of the contract between the post office and the sub-postmasters to confer an enforceable training benefit on the assistants.
Ah, so applying that Dolphin Maritime test in Chudley, protecting investors was a purpose. In Bates, benefiting assistants was merely an incidental effect. That contrast really clarifies the rule.
It absolutely does. You need to look closely at why the term is in the contract.
Okay, so if a third party does successfully meet the Section 1 tests, what rights do they actually get? What can they do?
Good question. Firstly, Section 1.4 makes it clear that the third party's right to enforce is subject to and in accordance with any other relevant terms of the contract. Meaning the original contracting parties can put conditions or limitations on the third party's right within the contract itself. They could say, for instance, the third party must make any claim within 6 months or must use arbitration. The right isn't absolute. It's shaped by the contract.
So the original parties still control the fine print of the right they're giving. What about remedies? Can the third party get damages, for example?
Yes. Section 1.5 is very important. It says the third party has available to them any remedy that would have been available if they had been a party to the contract. This includes damages, injunctions, specific performance, the whole range, subject to the usual rules for those remedies.
So this directly fixes the Beswick problem for the widow. She could now sue for specific performance in her own name.
If the contract was made after the Act came into force, yes, she could potentially seek specific performance or damages directly under S.15.
And what about those exemption clauses, like in Scrutton's? Can a third party use the Act to get the benefit of a clause limiting liability?
Yes, absolutely. Section 1.6 explicitly states that the Act applies to terms that exclude or limit liability. So a third party can enforce a negative benefit protection from being sued or having liability capped, provided the requirements of Section 1 are met. This directly reverses the outcome in Scrutton's on similar facts, assuming the contract wording fits Section 1.
Okay, that's a major change for exemption clauses. Now, Section 4 says the third party's right is additional to the promisee's right.
Correct. Section 4 preserves the right of the original promisee, the party who obtained the promise for the third party's benefit, to enforce the contract themselves. So potentially, both the promisee and the third party could sue the promiser for the same breach.
Couldn't that lead to the promiser having to pay out twice?
The Act foresaw that. Section 5 deals with preventing double liability. It says that if the promisee has already sued and recovered damages from the promiser in respect of the third party's loss, or the cost of making good the default for the third party, then any award of damages to the third party in their own subsequent claim must be reduced accordingly.
Sensible safeguard. Now, a really important practical question. Once a third party gains rights under this Act, can the original two parties just agree between themselves to change the contract and take those rights away?
Generally, no. The Act gives the third party's rights some protection once they have crystallized. Once the right has crystallized, the original parties, A and B, cannot, by agreement, rescind the contract or vary it in a way that extinguishes or alters the third party's right without their consent.
Okay, crystallized. When does that happen? When does the right become protected?
Section 2.1 tells us, crystallization happens when either of two things occurs. 1. The third party communicates their assent to the term to the promisor. They essentially say, yes, I accept this benefit. 2. The promisor is aware that the third party has relied on the term, or the promisor should reasonably have foreseen that the third party would rely on the term, and the third party has, in fact, relied on it.
So either active acceptance or reliance that the promisor knew about or should have foreseen.
Yes. Once one of those happens, the third party's right is locked in, and the original parties need their consent to change it. However,
There's always a however.
there often is. Section 2.3 provides a major exception. It allows the contracting parties to expressly provide in the contract that they can rescind or vary the contract without the third party's consent, or that the third party's consent is only required in specific circumstances different from those in Up.21.
So they can contract out of the default protection. If they put a clause in the original agreement saying, we can change this deal anytime without asking the third party, that overrides the crystallization rule.
Exactly. The parties retain significant control through the drafting of their contract. This highlights the importance of reading contracts carefully.
Definitely. Okay, what about defenses? If the third party does sue the promisor, can the promisor raise arguments they might have had against the original promisee?
Yes, Section 3.2 says that the promisor can raise against the third party any defense or set-off arising out of the contract that would have been available to them if they had been sued by the promisee.
So, if the promisee hadn't paid the promisor could use that as a defense against the third party trying to enforce a related benefit.
Generally, yes. The idea is the promisor shouldn't be put in a worse position just because the claimant is the third party.
Makes sense.
And Section 3.3 allows the parties to go further in their contract and agree that the promisor can raise any defense or set-off they have against the promisee, even if it's unrelated to the term the third party is enforcing. But the source notes this requires clear contractual intent.
Okay. Section 7.2 mentioned limiting liability for negligence.
Just a clarification point, really. Section 7.2 confirms the Act doesn't stop parties limiting or excluding liability for negligence, other than for death, personal injury, which is covered by other laws like UCTA, when performing obligations that benefit the third party.
Right. Now, crucially, how does this shiny new 1999 Act interact with all those older common law devices or workarounds we talked about earlier? Does the Act wipe them out?
No, absolutely not. This is a critical point, especially for exams. Section 7.1 of the Act explicitly states that the Act does not affect any right or remedy available to a third party apart from the Act.
So all those common law routes agency, trusts of promises, the Eurymedon device, enforcement by the promisee, they all still exist.
They all still exist. The Act provides a new, often more direct statutory route, but it runs alongside the existing common law possibilities. A third party might choose to use a common law route if, for instance, the Act doesn't apply, maybe the S.1 conditions aren't met, or perhaps for strategic reasons. Section 7.1 even allows for the development of new common law exceptions in the future, although the need might be less pressing now.
So the Act adds a major tool to the toolbox, but it doesn't throw out the old tools.
Exactly. Which leads us nicely back to taking a closer look at those older tools that common law devices use to circumvent perfidy.
Okay, let's revisit them now we understand the Act. What was the first one again?
The most basic one, perhaps, is enforcement by the promisee.
Right. This is where the person who made the contract for the third party's benefit, the promisee, sues the person who was supposed to deliver the benefit, the promisor.
Precisely. Our figure 11.3 example. A promises B to pay C £100. If A doesn't pay C, B can sue A for breach of contract. B is a party, so B has standing to sue A. And remember, Section 4 of the 1999 Act confirms this right continues even if C also has a right under the Act.
Okay, so the promisee can always sue. But what were the problems with relying on this as a solution for the third party?
Two main problems. First, the promisee B might simply be unwilling or unable to sue A. Maybe they don't want the hassle or the cost, or they've fallen out with C. And C, the third party, generally can't force B to sue.
So C's benefit depends entirely on B's willingness to act. That's a big practical issue. What's the second problem?
The second, often trickier issue is about the remedy B can get. If B sues A for not paying C £100, what is B's actual loss? The standard contract damages aim to put B in the position they'd be in if the contract was performed. If it had been performed, A would have paid £100, but to C, not to B. So arguably, B hasn't lost anything financially.
Meaning B might only be able to recover nominal damages like £1, which doesn't help C get their £100.
Exactly. This is the black hole problem. This led to discussions about whether the promisee has a performance interest, an interest in simply seeing the contract performed. But courts, like in Panatown v. Alfred McAlpine Construction Ltd. 2000, have been reluctant to award substantial damages to the promisee based just on that, especially when the real loss is C's.
But were there any situations where the promisee could get a meaningful remedy that helped the third party?
Yes, sometimes. We saw in Beswick v. Beswick that where damages for the promisee are inadequate, like zero, the court might award specific performance, ordering the promisor, A, to actually perform the promise for the third party, C. Wood R. v. Wimpy Construction, 1980, supported this possibility in a Beater comments.
Specific performance makes sense. Force them to do the thing they promised. What about damages? Any exceptions there?
A few limited ones. Lord Denning tried to carve out an exception in Jackson v. Horizon Holidays, 1975, allowing someone who booked a family holiday to recover damages for the whole family's disappointment when it was disastrous. But the House of Lords later narrowed that down in Wood R. v. Wimpy, suggesting it might be limited to specific types of contract like holidays.
Okay, limited scope there. Any more solid exceptions?
Yes, the most significant is the Albazero exception from the case the Albazero, 1977. Lord Diplock carved out a specific exception mainly for contracts for carriage of goods.
Right, explain the Albazero scenario again.
Okay. Seller A contracts with carrier B to ship goods. While they're at C, A sells the goods to buyer C. C now owns the goods. B, the carrier, damages the goods. C suffers the loss, but C has no contract with B, so can't sue B easily. A has the contract with B, but A doesn't own the goods anymore, so A hasn't suffered the loss.
The party who can sue has no loss. The party with the loss can't sue. The black hole again.
Exactly. The Albazero exception says, where A contracts with B contemplating that the goods will be transferred to C, and if C doesn't acquire direct rights against B, then A can sue B and recover substantial damages representing C's loss, holding that money for C.
Practical solution for that specific commercial context. Does it get extended?
Yes. Linden Gardens Trust v. Lanesta Sludge, 1993, extended it to building contracts where the parties knew the property might be sold to a third party. The original employer, B, could sue the contractor A for defects causing loss to C. Darlington v. Wilshire Northern, 1995, went further, applying it even where C already owned the property when B contracted A to build on it.
So covering future and existing owners in building scenarios, too.
It seemed quite broad for a time, but then came Panatown v. Alfred McAlpine Construction, 2000 again. The House of Lords put a major brake on these extensions.
What was the key point from Panatown?
The key point relevant here was, if the third party, C, has a direct remedy against the promisor, A, for example, under a separate duty of care deed as in Panatown, or potentially now under the 1999 Act, then these Albazero-style exceptions allowing the promisee to sue for C's loss will generally not apply. The law expects C to use their own direct route if they have one.
Okay, so the promise suing for the third party's loss is now more of a fallback if the third party has no other way in.
That seems to be the position after Panatown. One other small point on promisee enforcement. Snelling v. John G. Snelling, 1973, suggested if A promises B not to sue C, B might be able to get a court order to stop A suing C. But there were technical difficulties raised in another case, Gore v. Vanderlaan, 1967.
So, enforcement by the promisee. Possible, but fraught with difficulties regarding remedies, though specific performance can work, and the Albazero exception exists but is limited, especially if the third party has their own claim.
A fair summary, it's not a reliable route for the third party in all cases.
Okay, device number 2, agency.
Right. Now, agency isn't strictly an exception to privity. It's more a situation where privity is established from the outset, just maybe not obviously.
How does that work?
If A, the principal, authorizes B, the agent, to make a contract with C on A's behalf, the contract that B makes is legally considered to be between A and C. The agent effectively drops out of the picture for enforcement purposes. So A, who might have seemed like a third party initially, is actually a direct party to the contract with C through their agent B. Figure 11.4 shows this.
So the agent acts as a bridge, creating a direct contractual link between the principal and the other party.
Exactly. The source mentions Shanklin Pier Ltd. Detail Products Ltd. 1951 here. Remember, the pier owner, C, told their contractor, B, to use paint made by Detail A based on assurances Detail A gave directly to the owner, C. When the paint failed, the court found a way for the owner, C, to sue the manufacturer, A, directly, partly using agency reasoning and also collateral contract reasoning. It established that direct link.
So agency principles can be used, sometimes creatively,
Yeah.
to connect parties who might otherwise seem separate.
Well, yes, in the right circumstances. And some specific statutes also use agency concepts to overcome potential privity issues.
Okay, agency creates privity. Device number 3, the Eurymedon device, specifically for exemption clauses.
Yes, this is the complex but clever one developed directly in response to the problem highlighted in Scrutton's. Remember the scenario, figure 11.5. Owner A contracts carrier B hires stevedore C, C damages goods, A sues C. C wants to rely on the limitation clause in the AB contract. Scrutton said no.
Right. So how did the Eurymedon, full name New Zealand Shipping v. Satterthwaite 1975, get around this?
The Privy Council in the Eurymedon, and later the House of Lords applying it in Port Jackson, Stevedoring v. Salmon and Spraggan, the New York Star, 1980, constructed a separate collateral contract directly between the owner A and the cedidor C. It's a multi-step piece of legal reasoning shown in figure 11.6.
Okay, walk us through the steps from figure 11.6 again.
Step 1. The limitation clause in the main contract between owner A and carrier B, which says it covers B and B's agent subcontractors, like C, is interpreted as a unilateral offer from A to C. The offer is, if you unload my goods, I grant you the benefit of this limitation clause. Carrier B is seen as acting as C's agent just for the purpose of communicating this offer.
Okay, the clause itself is an offer to the stevedores.
Step 2. The stevedore C accept this offer by actually performing the service unloading the goods. This act of unloading is deemed to be the consideration provided by C to A for A's promise of limited liability.
Even though C was already obliged to unload the goods under their contract with B.
Yes, that was the controversial bit, but the court accepted that performing, or promising to perform, an existing duty owed to a third party, B, could be good consideration for a promise from A. It's the key to making the device work.
Okay, offer and acceptance plus consideration.
Step 3. This creates a separate collateral contract directly between owner A and stevedore C. The terms of this contract include the limitation clause.
So step 4.
Now, when owner A sues stevedore C in tort, C can rely on this new AC collateral contract and use the limitation clause within it as a defense. Privity is satisfied on this new contract.
Wow, that is intricate. A judicially constructed solution to a commercial problem.
Highly intricate, yes. Driven by the need to make these clauses work as intended in the shipping world. Lord Gough in the Makutai, 1996, acknowledged how far the law had swung from the strictness of Scrutton's thanks to this device.
But does this device still matter much? Now we have the 1999 Act, Section 1.6, lets third parties use exemption clauses directly.
That's the question the source raises. The Act certainly provides a much simpler route for exemption clauses now, and Section 6.5 deals specifically with sea carriage. So, the Eurymedon might be less needed for that specific purpose. Whether it could be adapted for other types of benefit is debated, but the Act's S11B is probably the go-to route now.
Given its complexity, you'd probably try the Act first. What were the conditions needed for the Eurymedon device to work, based on Lord Reed's points and Scrutton's?
Lord Reed set out 4 conditions that the Eurymedon effectively satisfied. A. The AB contract must make it clear the third party C is intended to be protected. B. It must be clear B is contracting as agent for C regarding the clause. C. B must have authority from C to act as agent, or C must ratify it later. D. C must provide consideration to A, which was the act of unloading, quite specific requirements.
Very specific. Okay, device number 4, collateral contracts more generally.
Yes. This overlaps a bit with agency and the Eurymedon. The basic idea is finding a second separate contract linked to the main one.
How does it help a third party?
Imagine A makes a promise or statement to B, trying to persuade B to enter into a main contract with C. That promise from A to B can sometimes be treated as a separate binding collateral contract between A and B. The consideration B provides for A's promise is the act of entering into the main contract with C.
So A might be a third party to the main BC contract, but they are a party to the AB collateral contract.
Exactly. A can be sued by B on that collateral contract or might gain rights under it. The source mentions Andrews v. Hopkinson, 1957, as an example, and we already talked about Shanklin-Pier, which fits here too. The manufacturer's promise to the pier owner induced the owner to contract with the contractor.
So finding a side deal based on an inducing promise.
Yeah.
Got it. What about device number 5? Trusts of promises.
Ah, the trust. This was historically quite important. The idea is that when A promises B to confer a benefit on C, B, the promisee, might be considered to hold the benefit of A's promise on trust for C, the third party. B becomes a trustee, C becomes a beneficiary.
And if there's a trust, what can the beneficiary do?
Equity steps in. The beneficiary, C, can compel the trustee, B, to sue the promiser, A, to enforce the promise. If B recovers damages, B holds them for C. The classic case suggesting this was possible is Lloyds v. Harper, 1880.
So C doesn't sue A directly, but uses trust law to force B to sue A for C's benefit.
That's the mechanism. In theory, it bypasses privity because C's right comes from the trust, not the contract.
But you said this isn't used much now.
Correct. It's largely fallen out of favor. Why? Because courts became much stricter about finding an intention to create a trust. In the old days, courts might have inferred a trust just to get around privity. Now, following cases like Rees-Shebsman, 1944, you need clear evidence that A and B actually intended to create a trust of the promise. That intention is rarely present or provable.
So unless the contract uses specific trust language, it's unlikely to work today.
Very unlikely. Although, interestingly, some judges in Darlington, BC v. Wiltshire suggested in Oliter that the specific wording there might have created a trust. But generally, it's a difficult argument now.
And the final route, number 6.
Simply other legislation. Parliament has stepped in over the years in specific areas to directly overcome privity for certain types of contract.
Could you give examples?
The source mentions the Third Parties, Rights Against Insurers, Act 1930, Sections 56 and 75 of the Consumer Credit Act 1974, and Section 56 of the Law of Property Act 1925. We don't need the details, but the point is, if you're dealing with insurance, consumer credit, or property, you should check if a specific statute already gives the third-party rights.
Okay, so summing up the common law devices. Judicial creations to soften privity's impact, often complex, sometimes inconsistent, but still legally available thanks to the 1999 Act, even if the Act is often the simpler route now.
Well put. They show the common law's flexibility, but also why statutory reform was ultimately needed.
We've focused heavily on third parties getting benefits. Let's flip it around. Can a contract impose a burden or liability on a third party?
Good question. This takes us right back to the first aspect of privity. Only parties are bound. So the general rule is a clear no. A contract between A and B cannot impose an obligation on C.
That example of our contract making our neighbor mow your lawn still a non-starter.
Still a non-starter. The source briefly touches on whether contractual burdens could run with property other than land, like ships or goods, similar to restrictive covenants on land. But the legal position in English law is uncertain and generally leans against it.
Any case law on this?
Conflicting stuff. Lord Strathcona Steamship v. Dominion Coal, 1926, suggested a burden might follow a ship if the new owner knew about it, but that case was specifically disapproved in Portline v. Benline Steamers, 1958. Swiss Bank v. Lloyds Bank, 1979, didn't really clarify things. So the core principle remains. You can't use a contract to impose duties on non-parties.
But is there any way a third party can end up bound by terms in a contract they didn't sign, especially involving goods?
Yes, there is one significant area, sub-bailment on terms. But again, it's not the contract itself imposing the burden directly. It's the legal relationship of bailment combined with the owner's consent.
Okay, explain sub-bailment again.
Bailment is when an owner, A, gives possession of goods to someone else, B, the bailee, for a purpose, like storage or carriage. If B then gives possession to another person, C, the sub-bailee, usually under a contract between B and C, that's a sub-bailment. That BC contract will likely have terms and conditions.
Owner A, bailee B, sub-bailee C under a BC contract.
Exactly. The big case here is the Pioneer Container, KH Enterprise v. Pioneer Container, 1994. Cargo owners, A, contracted with carriers, B, who then subcontracted the actual C carriage to ship owners, C. The contract between B and C, the sub-bailment, contained a term saying any disputes had to be heard in Taiwan, an exclusive jurisdiction clause.
Okay, the goods were damaged. Could the ship owner C force the original cargo owners A to sue them in Taiwan based on the BC contract clause, even though A wasn't party to it?
Yes, the Privy Council said A was bound by that clause.
If A wasn't party to the BC contract?
This is the key. A was bound not by the BC contract directly, but because A had consented to B subbailing the goods on any terms. That consent was found in the initial A-B contract, the bill of lading. By agreeing that B could subcontract on any terms, A was taken to have accepted that they would be bound by the terms of whatever subbailment contract B entered into with C, including C's standard terms like the jurisdiction clause.
So it's the owner's original consent to the possibility of sub-bailment on terms that creates the link and binds them to the terms later agreed between B and C.
Precisely. It flows from the bailment relationship and the owner's authorization, not from the principle that contracts can impose burdens generally. It's a specific mechanism for bailment chains.
That's a really important distinction. Liability imposed via consent within the bailment structure, not by the contract itself reaching out to bind a stranger.
Exactly. Outside of specific contexts like this, imposing burdens on third parties remains very difficult.
Right. We have covered a huge amount of ground. From the old strict privity rule,
Through the cases that showed its flaws.
to the major statutory reform in the 1999 Act.
And the common law devices that existed before and continue alongside it.
It really shows how the law has adapted over time.
Trying to balance principle with practical realities and fairness.
Okay, just to consolidate for everyone listening, especially those facing exams, let's quickly recap the absolute key takeaways.
Good idea.
Privity. Generally, only parties can sue or be sued on a contract. Two aspects. Burden, can't impose on C, generally okay, and benefit, can't give C enforceable rights, historically problematic.
Key cases showing the problem. Twiddle v. Atkinson, family promise blocked. Dunlop v. Selfridge, price control blocked. Scruttons v. Midland Silicones, exemption clause blocked for stevedores. Biswick v. Biswick, widow's annuity blocked in her own right. Remember those names and facts.
Then the big fix. The contracts, rights of third parties. Act 1999. Purpose. Give effect to parties' intention to benefit C. How it works. Section 1.1, express provision, or Section 1.1b, term purports to confer benefit, BUT, qualified by Section 1.2, unless parties didn't intend enforceability. Third party must be identified, Section 1.3.
Remember the key cases on applying Section 1. Niche shipping, commission enforceable. Prudential v. Ayers, sole purpose not needed. Gulf and Maritime, purpose versus incidental effect test. Chudley v. Clydesdale, investor protection, purpose enforceable. Bates v. Post Office, assistant training incidental, not enforceable. That distinction is vital.
Rights under the Act. Subject to contract terms, Section 1.4, full range of remedies, Section 1.5, includes exemption clauses, Section 1.6. Promisee can still sue, Section 4, but no double recovery, Section 5. Variation rescission. Protected after crystallization, Section 2.1 via assent or reliance, unless parties contract out, Section 2.3. Promisor has defenses, Section 3.2.
And crucially, the Act preserves common law rights, Section 7.1. So those devices still matter. Enforcement by promisee, but issues with remedies. Alba Zero exception limited by Panatown. Agency creates privity. The Eurymedon complex collateral contract for exemption clauses, less needed now. Collateral contracts generally, trusts of promises, rarely works now due to intent requirement. Other specific legislation.
And finally, imposing burdens on third parties. Generally no, except via specific mechanisms like sub-bailment on terms with owner's consent, the Pioneer container.
That covers the main landscape.
And thinking about exams, this topic is bread and butter. Essay questions, problem questions, it comes up all the time.
Definitely. Let's quickly apply this to those sample questions mentioned in the source. Question 1. Death and service benefit for widow.
Like Biswick.
Exactly. You'd state the privity problem, Twiddle Dunlop. Then discuss the Bestwick common law route. Can she sue as administratrix? Yes, specific performance likely. Then, crucially, apply the 1999 Act. Can she sue in her own right? Check S.1b, purports benefit, S.1.2, intention rebutted, S.133, identified. Likely yes under the Act. Discuss remedies under S.115, show both common law and Act analysis.
Question 2. Dodgy dam proofing. Refund promised to homeowner F by daughter G's contract with builders.
Again, start with privity F. F isn't party to G's contract. Apply the 1999 Act to F's potential claim against builders. Does the work term purport to benefit F, S11B? Was it a purpose, Dolphin, Chudley test? Does the refund promise purport to benefit F? Analyze under S11B and S12. Then consider G's, the promisee's position. Can G sue for F's loss? Discuss Jackson, Lindham Gardens, but remember the Panatown limitation if F can sue under the Act.
So for problem questions, identify the third party. State the privity issue. Analyze common law routes, as Barry promising enforcement, maybe agent side trust if relevant. Systematically apply the 1999 Act, S1136. Consider remedies and defenses. Cite key cases and sections throughout.
Precisely. And for question 3, the essay, Privity is largely irrelevant now. You need to argue both sides. Yes, the Act massively reduced its impact for intended benefits, explain S.1, but no, it's not irrelevant because 1, Act reform didn't abolish, 2, Act doesn't apply if parties exclude it, S.23, or if S.1 tests fail, for example, incidental benefit. 3, Act doesn't help impose burdens. 4, therefore, common law privity and common law devices, preserved by S.7, remain relevant in those situations. Show the nuance.
Excellent. So knowing the cases, the Act sections, and how they interact is absolutely key. Repetition helps. Total, Baswick, Eurymedon, Albazero, Panetown, Nishin, Chudley, Bates. Sections 1, 2, 3, 7 of the Act. Nail those down.
It's a journey the law has taken, from strict rules to trying to find more practical, intention-based solutions.
It really is.
Yeah.
Understanding who gets to enforce these agreements is just fundamental to how contracts shape our interactions.
Shows the law isn't static. It evolves to meet needs.
Well, that was an incredibly detailed deep dive. We've explored the history, the problems, the big legislative fix, and the common law backdrop that still exists.
Hopefully that clarifies things for anyone grappling with this topic.
So, as we finish, a final thought for you to take away, building on our discussion. Given that the 1999 Act allows contracting parties to easily contract out, to include a term saying the Act doesn't apply, or that they can change the deal without the third party's consent, Section 2.3, does this power mean that the old potential for injustice under privity hasn't really gone away? Does it just depend now on whether parties are knowledgeable enough or perhaps powerful enough to exclude the Act's protections when they draft the contract?
It certainly raises the question of whether the default position under the Act is strong enough if it can be so easily overridden by the original parties. Something to ponder.
Indeed. We hope this exploration has been helpful for your understanding.
And just a reminder, the materials informing this discussion were made available by the University of London for educational purposes.
And this deep dive was brought to you by Sinorbit Academy, Sri Lanka.
Once again, seriously, good luck for all of you for the exam.
Thank you so much for joining us on the deep dive. We'll catch you next time.